Hey, everybody. Here we go. Welcome to another episode of CRESI's Ontario Landlord Series, a podcast for Ontario-based landlords so that you are getting the right, correct information to make your landlording experience the best it can possibly be. We cover lots of things on this show. We have experts always coming in. Today, we're joined by a past guest, a good friend. We call him the lawyer in our network. He is Gibrian Malicki-Sanchez, a third-generation lawyer at his firm. He spoke to us before in generalization about a lot of things that can happen after and what to do when a hearing doesn't go your way. Today, we're going to talk about a specific one, and that is the Divisional Court of Appeals. So, Gibrian, why don't you come on, say hi, introduce yourself again. You'll do a better job than I do, and let's get into why this can happen.
Hi, Kevin. Thanks for having me on again. I'm happy to be able to share information to landlords and anybody experiencing the Landlord and Tenant Board. Yes, today I'm going to be talking about Divisional Court Appeals. And I guess I should first explain what an appeal is. So simply, it's a legal process where a party asks a higher court to review a decision made by a lower decision court maker, such as a Landlord and Tenant Board. So it's important to know that an appeal is not a new hearing, and it's not a chance to re-argue your whole case. Instead, it's a review of whether the original decision maker, the Landlord and Tenant Board, has made a legal error. Okay?
Can both sides request an appeal?
Of course. Both sides can request an appeal. And the timing for that is as follows. So you've gone through the entire Landlord and Tenant Board process. You had the board member issue a decision. Before enforcement really begins, there's a 30-day period that everybody should be aware of. Either party can do one of two things. One, you can request that the board reviews its own order, and that's on a basis that the board has made a serious error, or one of the parties was not reasonably able to participate. That's not what I'm going to talk about today. I'm going to talk about the other one, which is an appeal to the divisional court. And just so you know, your option to appeal to the divisional court is based on whether you believe the board member misinterpreted the law or applied the wrong legal test or even made a serious procedural mistake.
Just because this isn't very common, and I know that this is going to be a great episode for everyone out there to really digest and understand how this can, what would be their process if they ever did get into this situation. But when we're talking about both being able to appeal, and then you mentioned that it could go back to the LTB first before going to the divisional court. You mentioned that can only be done if you're challenging them on an error that they have made, correct? Did I say that right?
In law.
In the law. So not if you disagree with their judgment. It has to be an error in law to go back to them. Can they go back just on an error in law for both? Like it has to be about an error, or it can be about anything when they're going to the Divisional Court of Appeals?
It has to do with the law.
It has to do with the law and how they judged on what that happened.
Okay. Exactly. Okay, so this is set out in the Residential Tenancies Act at Section 210, where it says any person affected by an order of the board may appeal the order to the divisional court within 30 days after being given the order, but only on a question of law. So that's how we know that it's distinguished by law. And again, if you want to know more about serious error or not reasonably able to participate, that's set out in the Landlord and Tenant Board Guide, which is on the Landlord and Tenant Board website. The Residential Tenancies Act also sets out what the divisional court can do, and it can affirm, rescind, amend, or replace the decision or order made by the Landlord and Tenant Board, or even remit the matter to the board with the opinion of the divisional court so that it can apply the correct law. The divisional court can also make any order in relation to the matter that it considers proper.
Sorry to jump in there. And I just want to give maybe two examples so that we can let our listeners understand exactly how this possibly could come about, one from the landlord side and one from the tenant side. So the landlord has been granted the eviction notice for the tenant on non-payment of rent. And then let's say the other one, so the tenant is the one who has appealed to the court to challenge the eviction notice for their non-payment of rent. The other one where the landlord has gone to the appeals because they didn't like the remedy or the solution for an order that was placed based on not where they had received an order on maintenance, repairs, and issues that way that they had lost that way. So they're appealing and challenging the outcome from the board that way. Are those two good examples that we can work off on both sides?
Yeah, we can talk about those. So I would caution landlords that tenants may abuse the right of appeal. Because what happens when, in your example, there's an order for eviction, the tenant hasn't paid rent for months, right? And there's a deadline in the order for them to pay. Otherwise, that order can be filed at the sheriff's office, who will schedule time to evict the tenant. Well, if the tenant makes an appeal to the divisional court by filing a notice of appeal, then the divisional court can put a stay on that landlord and tenant board order until the appeal process has gone to the appeal hearing, and then the divisional court judge or judges, depending if it's a panel of three, makes a decision. And that appeal court process can take many months. And if that landlord and tenant board eviction order has been filed at the sheriff's office already before the 30 days, before the tenant filed the served you with the notice of appeal, then when the sheriff comes to the scheduled time, they will be notified by the tenant that there is a certificate of stay. So then they won't be able to kick the tenant out. There are things that we can do to deal with that, which I can get into a little bit later. But that's typically not going to be something where the board member had made an error in law. It's just a way of the tenant trying to buy some more time for themselves. This kind of dovetails into your other question about on the landlord's side. If they think that the board member had made an error in law, what you'll see in these landlord and tenant board decisions is a detailed analysis about the evidence that was tendered at the hearing and how the landlord and tenant board member weighed that evidence and applied it against the Residential Tenancies Act and the case law and gave reasons for their decision. So if you want to appeal a decision on an error of law, you look at those reasons. What sections of the Residential Tenancies Act was cited? Was the proper legal test used? Look at the case law that was referenced. Were the legal tests in those cases used as well? Were the precedents that were followed used as well? And if you can tell that the law was misapplied, then you will want to raise that issue with the divisional court and say, look, the law was not applied properly. The right test wasn't used. We need you to fix this.
Gotcha. Thank you. The point here, I guess, is that everyone needs to realize that it has to be a challenge to a misappropriation of the actual law itself, not just wanting to challenge the tender, anyways, the hearing result.
Yeah, and let's face it, Kevin, the Residential Tenancies Act is not very clear in some situations. For example, you can file an application against a tenant for persistently late payment of rent. But the Residential Tenancies Act, it doesn't tell you what constitutes persistent late payment of rent. That will typically come down to the discretion of the board member. And because there's some discretion there, there's an opportunity for somebody who doesn't like the judgment to say, I think that they misapplied the law. I don't think that, they discounted the fact that the tenant was late twice. That should be persistent. The board member didn't issue an order for eviction on that basis. Then you could appeal that to the divisional court and ask, was that law applied properly? So a lot of times when a representative or self-rep is trying to argue or make submissions at a landlord and tenant board hearing, they will reference case law and referencing previous landlord and tenant board hearing orders is fine, but like the authority would be decisions from the divisional court where they have given examples of what would be considered persistent late payment of rent, for example. And again, it does come down to the discretion of the board member in circumstances, but you'll want to find a case that supports your position in your fact scenario.
Perfect. No, that's what we need. The clarification through everything is, like you said, there's gray areas, there's discrepancies through a lot of this, and that's, I think, where some issues lie for sure.
Mm-hmm. Yeah, so I'll talk a little bit more about what to expect at the divisional court and some resources that you can look at. So I want you to be aware that the Courts of Justice Act is another act, and Section 134 of that act talks about the powers that the divisional court or court of appeal can take on an appeal. And so it sort of dovetails with what's in the Residential Tenancies Act, that they may make any order or decision that ought or could have been made by the Landlord and Tenant Board or the tribunal being appealed from, or order a new trial, or make any other order or decision that is considered just. So just because the Divisional Court of Appeals, like, yeah, you know what, the board member made a mistake, it doesn't mean it's going to go back to a hearing where all the evidence has to be tested again. The Divisional Court could make its own order. Now, the process that people need to follow is set out in another another statute called the Rules of Civil Procedure. And the particular section you want to look at is, like, it's set out in Rule 61, and that gives the timelines of filing it sets out what documents need to be filed and when they need to be filed. So I'll quickly go into that, and it shouldn't be overly complicated. I don't want to make it that complicated. There's just a few steps. Basically, the appellant starts it, then the respondent has a chance to respond, and then there's a few steps along the way. But the timelines are important and they need to be followed. And if they're not followed, then, like, let's say the tenant who hasn't paid rent filed a notice of appeal, or they filed a notice of appeal within the 30 days. All right, you're good. If they filed it after, then they're basically statute barred, and you may have to bring a motion to get that dismissed if the Court of Appeal doesn't already do that automatically, if it slips through the cracks. But within 30 days of, the appellant, the tenant in this case, serving the landlord with the notice of appeal, they have to order a transcript. If they don't order the transcript within 30 days, then again, bring the motion to dismiss. Once, you've been served with a notice of appeal, if you're the landlord, then you have 15 days to serve the appellant with your certificate respecting evidence. Along with a notice of appeal, the appellant has also served their notice respecting evidence. So let me just talk a little bit about what the notice of appeal is. It sets out the grounds for the appeal, and it sets out the order that you're seeking. So obviously it's asking for an order to stay, but then it says, like, in the reasons given, this law was wrong and this is what it should be, and this is the authority that I'm relying on that sets out what the correct law to be applied is. So it gives notice to the respondent as to what the test is that they have to meet, what's going to be challenged and going to be put as issue in front of the divisional court judge. So anyways, the appellant has to perfect their appeal, and it has to be perfected within 60 days of the appellant receiving notice that the evidence that they want to be transcribed will be transcribed. And if they don't do that, again, you could bring a motion to dismiss. The appellant must also, to perfect their appeal, serve an appeal book and a compendium. And if you want to know what's in there, that's, again, set out in Rule 61 of the Rules of Civil Procedure. An exhibit book, the transcript of the evidence, and their factum. And the factum basically says, these are the issues, this is the case law, this is the authority, so any acts that they want to refer to, and then they state why their position is the correct one. And then the respondent will have to file their own factum and compendium as well. So those are the documents that are required. Typically, no new evidence will be admitted because, again, the divisional court judge is not testing the evidence. They just want to hear the law, and they can make inference from the evidence that's set out in the decision. But you could file new evidence in some situations. For example, you know, there in one that I was involved in, there was a rent to own contract, and the tenant had possession of the rental unit, of course, and was suing the landlord for breaching the rent to own contract because um, the landlord wasn't going to sell the property to them. So they started a claim in the Superior Court, but the landlord wanted to move into the property, so served an N12 and brought that to the jurisdiction of the Landlord and Tenant Board and was successful. So the tenant appealed it, saying that the Landlord and Tenant Board didn't have jurisdiction because it was already in the Superior Court. So in that case, the evidence in the Landlord and Tenant Board was one thing, but evidence that was being used in the Superior Court hearing that was relevant to the determination of this issue could also be brought in. So I'm just giving an example of how you may still need to bring in some other evidence.
Just because you're saying that, and now I'm onto that. Wouldn't the agreement of purchase and sale that the rent to own contract was done on overtake or be more? I don't even know the terminology here. Anyway, shouldn't it be more relevant or more powerful than the actual RTA saying or the N12 form, because he's already sold it technically?
Yeah. So, Kevin, as we always say on this podcast, every situation is different and you have to get your own legal advice. In this particular case, there's allegations that that contract was fraudulently signed and was not in effect or enforceable. So, in fact, since there was no contract to purchase, that's completely irrelevant. All that matters is that there's a landlord and tenant relationship, and that's why the landlord and tenant board should have jurisdiction.
Gotcha. And you're right. Everything that we're talking about is in generalities, folks. Nothing is specific. If you do need any type of guidance or advice, Gibrian's contact information will pop up, I'm sure, a few times through this podcast, as well in bios or everything like that as well. Plus, all the documentation and things that he's referring to will be able to be found through our resources as well. So, not to worry. But at the end of the day, don't do it yourself. Talk to Gibrian, and let's keep on moving here.
Yeah, so there are some good resources for people to refer to, um, in addition to the rules. For example, you should be looking at the practice directions for the Ontario Court, and we can post a link to that. And that basically tells you where to file, how you name documents. So that's very important to do if you want to do this on your own, or if you want to check to make sure that your representative is doing it properly. Why not? And then there's also resources for self-reps. We could also post a link there, which sets out pretty clearly the different steps in the appeal and the kinds of documents you want to use. If you're wondering about how you can request a hearing recording, which is, as we can see, pretty important in these appeals, there's a request for a hearing recording form, which we could also post in here. The appellant is the one who has to request the hearing recording, and they have to pay for it as well. So the respondent, the landlord, is not responsible for paying that. And then there's another link in order to request a certified transcriptionist to convert that recording into a transcript, which is what you need. Let me kind of give you a view of how a case could work when the tenant who hasn't paid rent is just trying to delay. There's typically directions that are sent to both parties by a divisional court judge stating that certain things have to be done. For example, the parties can agree to their own timelines for exchanging and submitting documents. the tenant would be expected to pay the amount of arrears into court or into a lawyer's trust account. Again, any situation could be different, but the divisional court wants to balance the rights of the parties and the prejudice to the parties, and it's considering that on the one hand the tenant is continuing to occupy the rental unit and the landlord has to foot the bill. That's not fair. What would be fair is if the tenant pays money into court or lawyer's trust account. It also can set out requirements for providing additional information that it wants. So if there is a dispute on the amount of rent owing, it gives the tenant appellant the opportunity to set out those particulars more fully. It would also set out when there's a case management conference. So a case management conference is the opportunity for both parties to go before a divisional court judge to confirm that everybody's complying with the timelines and that the matter's moving along well towards scheduling the actual hearing. So issues coming up of the tenant's not paying money into court, that could be a problem. People are not following the timelines. The divisional court judge could put things back on track, just to sort of get control of things. Now, at first instance, if you realize that there's really not an argument over an error of law to be made, and this appears to be a frivolous appeal or an abuse of the court process, then Rule 2.1.01 of the Rules of Civil Procedure says that the court may make an order staying or dismissing a proceeding that appears on its face to be frivolous or vexatious or otherwise an abuse of process of the court, which means that the respondent landlord can file a requisition to the court setting that out and explaining why that's the case, and then the judge can make a decision, but the appellant will have the opportunity to respond to that requisition themselves, and then the judge can make the decision there. So this is a little bit different than bringing a motion. It's not as formal. You don't have to make oral submissions or anything like that. It is read as what we call in chambers. So the judge will review it, and you could probably stop the appeal in its tracks right off the hop right there. So that's an important thing to know to kind of shortcut the entire process in a cost savings way.
Generally, again, from what I've come across and from what I've seen, and correct me if I'm wrong here, but whenever people are looking at a situation, an argument, a discrepancy between landlord and tenant, if the tenant is holding back rent, right, for months on end, thinking that this should have been done and wasn't, that's why I'm not paying rent. Most times they're not paying way more than what they're arguing over, right, by thousands of dollars. So I don't see, I haven't anyways, and I haven't done this a bunch of times, and I hope that I don't do it a bunch of times. But from what I've come across is that everybody does not, there's no reason you should live for free. I guess that's the way to say it, right? Even the Landlord and Tenant Board and the legal system there looks at a tenant that is up to date with their rent, fighting for money back, differently than when they look at a tenant that is thousands of dollars or months in arrears, fighting over a third of what they actually owe the landlord.
Yeah, and that specific situation, there's a lot of red flags there. So relying on that rule that I talked about requisitioning a dismissal or a stay of the order, which means if you lift the stay of the landlord and tenant eviction order, then you can proceed with eviction. But again, the judge would have to weigh the prejudice to the tenant doing that. So there's so many different kinds of orders. There's not always about eviction. Some orders can be stayed even using this process if you want to stay or lift the stay. So yeah.
Like everything, it can go this way or that way, and there's variables to everything, right? Every situation is specific and unto its own. So make sure that you are at least getting a legal guidance. If you're going to do it yourself, hey, listen, there's lots of people out there that choose to do it that way. Get all the information you can. Make sure you were crossing your T's and dotting your I's and following all these forms that Gibrian just mentioned and that we will post about how to do it properly, because I just know with the LTB, if you miss an address just by a little bit, you're getting thrown out. So it'll be the same thing there. And again, this is a business. It is a business expense. Professional advice, I think, will cost you less headache, less time, and less money versus going at it yourself. But that's just me. I always think that getting the guidance of the professionals is the best thing to do, even when it does cost you money out of your pocket, rather than just trying to do it yourself. I think all the judges and everything like that look at it differently. That's my personal opinion when you have representation versus when you're on your own. But as we discussed earlier off camera, this is a topic that doesn't normally get talked about online, and there isn't much information out there for everybody. So if this is something that you've learned from or have more questions about, let us know. We can dive into it some more if we need to on a general basis. Gibrian is just a phone call away or a click of a mouse, so you can get information directly from him as well. But like always, I learned something today. I hope you guys did as well. Do you have anything to leave us with today? Any last words?
Yeah, it's always good to get legal advice because there's different ways of getting the results that you want. Lawyers are very attuned to keeping the parties in check and in line. And if anybody slips, then you'll want to try to take advantage of that to the benefit of your client. So, yeah, I work at Malicki-Sanchez law firm. You got my contact information in your show notes, I'm sure. So, yeah, if you have any questions, get legal advice that's catered specifically for you and your situation. And I hope that this information was useful. We can get into any one of those areas a lot more. But Kevin, thank you for letting me share with your
No,
audience.
as always, thanks for sharing your expertise and wisdom. Gibrian is not just a lawyer, he's also an investor. And we've talked about it before, and we're going to bring him back on to talk about getting properties in the United States as well. So for our Ontario landlords that want to diversify and go a little bit south of the border, we can talk about that on another episode as well. We just got to plan that. But as always, thank you so much for joining us, Gibrian. I appreciate it. And we will see you again next time. Bye for now.
Thank you, Kevin.
Please remember, while we are professionals, this podcast is for informational and entertainment purposes only. The advice shared may not apply to your unique situation. Always seek personalized advice from a qualified professional before making any investment decisions.
Hey everybody, thanks so much for joining us this week. I hope you enjoyed the episode. If you're finding it informative and useful, make sure to like, subscribe, share with a friend so that we can keep getting the information out there to Ontario landlords. And keep on joining us. We'll see you next time.